Hello, hello, and welcome to another Ohio Estate Planning Secret Seminar. Today, we're going to talk about real estate investing and asset protection for real estate investors. Now, if you are new to the Ohio Estate Planning Secret Series, feel free to add your questions to the chat. Um, this is a very conversational dialogue. So if you have any questions, feel free to add them to the chat. And at the end, I'll give you an opportunity to unmute yourself so that you can ask those questions. Now, this seminar is specifically for rental property owners, individuals with small real estate portfolios, and any real estate investors with LLCs, or if you're thinking about getting an LLC put together, then this seminar is for you. In addition to this seminar being for you, this seminar will be going over asset protection, tools such as LLCs and trust, and we'll also be putting it together to see how it all works together. So again, if you have any questions, feel free to put those questions down in the chat so that I can answer them throughout our time today. So the first thing I want to talk about are the three biggest mistakes and the three biggest, I should say, risk that real estate investors face. Now, the first risk that they face are lawsuits. So there's lawsuits and liabilities. That comes from tenant injuries, contractor issues, and then related property claims. And so one of the biggest things that our real estate investor clients are concerned about is, look, who's going to be responsible for a tenant being injured on my property? If the tenant is injured on my property, am I going to be liable for that? And the answer is yes, you will be liable for any injuries from your tenant. Now, one of the things that you can do to protect yourself is to have the right legal structure in place so that you don't face that liability and your personal assets can be protected. Again, the next issue that we see as it relates to lawsuits and liability are contractor issues and then property related claims. A couple of weeks ago, I had a client whose tenant called him in the late hours of the night. I think it's around almost 10 o'clock at night on a Saturday night. And the tenant called because someone had ran into a fire hydrant and knocked the fire hydrant into the house. But more importantly, there was a bunch of water that was flowing downhill into the house. So the landlord went out there to check and inspect the property and to see if there was going to be a related property damage claim. And so, again, as a landlord or property owner that's renting out some property, you are facing potential lawsuits by tenants or liability by tenants. Then we have contractors. You might hire somebody to do work and they do work in a poor or a less than a quality workman manner, or there's related property damage claims. So that's the first risk that real estate investors face. The next risk that we see real estate investors face are the risk of their assets going to probate. And the reason why we see this as a risk is because most families are living off of the rental income. And if the income gets tied up into probate court, then those families can't access that money unless the probate court gives them permission and approval. And you can only imagine the complexities of this situation where a loved one passes away and we're waiting for the probate court to effectuate the plan that was already put in order. So that's the second risk, probate. And then the last risk that we see for real estate investors is some sort of long term care cost related to the nursing home. Now, we're going to talk about each of those, but one of the things that real estate investors come to me about is asset protection, but also long-term care costs. So if they have to go into a nursing home, what does that look like for their real estate portfolio that they've built? How do they protect those assets? And so today we're going to dive into the ways that you can protect your assets against those three big risks that we see real estate investors face. And I know a couple people just joined. Again, this is going to be kind of like a dialogue. So if you have questions, feel free to put them in the chat, and I'll be glad to answer those questions as we move forwards throughout our time today. Now, the first thing I want to kind of explain to everybody is what I call probate versus non-probate. And so I want to demystify the probate risk. So in general, probate is the legal process that is used to transfer assets from a deceased person to their loved ones. And so everything doesn't go through probate court. It just depends on how the assets are titled. So if I have an asset that's in my name only and I were to pass away, that would be considered a probate asset because I wouldn't be here to sign the deed on my house. I wouldn't be here to sign a vehicle car title. And so I need the probate court's assistance to transfer the asset to my loved one. So one of the most common non-probate assets is a life insurance policy, right? It makes perfect sense. Life insurance, you give them a copy of the death certificate, and then they make payment to your loved ones. But when it comes to real estate, you can have your real estate titled in a way that it avoids probate. And for a lot of people, that titling is some sort of survivorship deed or what we call a transfer on death designation, or their property is inside of their LLC. So if a piece of property is in survivorship, then it goes to the survivor of them and it avoids probate. Same with transfer on death. It goes to whoever that beneficiary is designated on the transfer on death as it relates to real estate, or it could be in an LLC. Now, if the property is in an LLC, it does not avoid probate, but rather whoever is now the owner or the manager of that LLC has control over the LLC. So if I have a piece of property that's in the name of my LLC and I pass away, technically the property doesn't have to go through probate court, but probate has to get involved to designate somebody to now manage the LLC since I'm no longer here and since I'm the owner of the LLC. So again, the property itself doesn't go through probate, but rather the probate court gets involved to manage or to designate somebody to be the manager. Now, my team and I are currently working on a case where a client had a corporation and the corporation did not have any directors, any other shareholders, and this corporation, pursuant to the deceased estate plan, gave specific instructions that the corporation was to be sold, and then the assets distributed pursuant to his will. And so that's what my team and I are working on. Number one, we had to get the executor appointed by the probate court to manage the corporation. And then once we had the authority to manage a corporation, we then have to sell it. So there's still some kind of steps, even if you have an LLC. But as we go on today, we're going to talk about how it all comes together and what your family can do to protect against the probate process altogether. Now, are there any questions out there before I move on? No. Okay. One of the other things that I like to kind of make sure that people are aware about, especially real estate investors, are what are the real costs of probate? Now, here's what I'll tell you. Under Ohio law, the administrator or the executor under a will is entitled to a fiduciary fee for an estate. Now, under the law, the fiduciary fee is 4% of the first $100,000, 3% of everything over 100 but less than $400,000, 2% of everything over $400,000, 1% of the real estate not sold, and 1% of all property not subject to administration. And so the example that I always like to give is if there's an estate that has $250,000 worth of assets, and that's $250,000 worth of probate assets, assets that have to be transferred by way of the probate court. Now, the probate court doesn't care if the real estate has a mortgage on it or not. They just care about the county's assessed value of real estate or an appraiser's value of personal property. So this 250,000 is just truly the 250,000 gross value of an estate. And so if we take 4% of the first 100,000, that's $4,000. And then we take 3% of the next 150, that's $4,500. That's $8,500 just in the fiduciary fee. Now, in addition to the fiduciary fee, the attorney who's handling the estate is entitled to a fee that models the same fiduciary fee. So that's $8,500 for the fiduciary and another $8,500 for the attorney handling the estate. So right there, we're at $17,000 in administrative fees for an estate worth $250,000. In addition to that, there's the probate administration fee for filing an estate with probate court. There are the recording fees and title fees to transfer real estate. And then if you don't have a will, or if you have a will, but the person that you designated is not an Ohio resident, they have to post a bond. And typically the bond is 2 times the value of all personal property. So if the personal property is, say, $50,000 in this example, the bond might be another $500 that has to be paid on an annual basis. Okay. And so we got the $500 bond, we have the probate fees, we have the attorney's fees, and the fiduciary fees. We're looking at on a minimum of $17,000, upwards of $20,000 for an estate that costs $250,000. Now, you might wonder, why does this matter to you? Because you're going to be gone anyway. Well, that's almost $20,000 that could have gone to your family, but instead is going to the fiduciary, the attorney, the probate administration fees. So all of this is very important because in addition to the $20,000, almost $20,000 in fees, there's a delay by having this go through probate. And again, if your family needs the cash flow to live their lives, this money is tied up in probate court, right? The probate court doesn't care about the income. They care about transferring the assets to the rightful heirs. And if that takes a year, then that's what they'll do. It'll take a year. If it takes longer than a year, we've had some estates that have been open for almost 3 years because the probate court has to be satisfied that the money is going to the proper party before they allow the executor or fiduciary to distribute the funds. And so one of the things that I always say is that if you really love your family, you'll keep them out of probate. And it is avoidable with the right structure. Moving on to LLCs for asset protection. So one of the things that we always talk about are how can you use an LLC for asset protection? So first off, I want to start with explaining what an LLC is. And an LLC is a limited liability company. And what an LLC does is it separates your personal liability and assets from your business liability and assets. And so the way I like to explain it to people is it gives you a layer of protection between your personal assets and your business assets. And so for our real estate investors, what that means is any asset that they have in their LLC is separated from their personal assets. So if the tenant slips and falls and gets hurt, they could sue the LLC, but the rental property owner does not have to worry that their personal assets are going to be subject to a lawsuit, but rather the LLC is going to stand in place for that liability. And the easiest way to think about it is the LLC is a separate legal entity from the person. So the assets that I have in my name are mine, and the assets that I have in the LLC are owned by the LLC, but I own the LLC. And so if a tenant were to sue me, the tenant could only go after the assets that are owned in the LLC. Now, there are some exceptions to that. And one of those exceptions are if I am the at fault party. And the best example that I always give people is this. If you own an LLC, so I own an LLC and I have a tenant, so I put a tenant in the property, and the HVAC heating and cooling unit needs repaired, and I go out and repair the heating and cooling unit. Okay, I fix it. Instead of contracting an HVAC personnel to come out and fix it, I fix it. And then it blows up and a tenant gets hurt. That tenant can sue the LLC because it's the property owner, but the tenant should also sue the person who negligently repaired the HVAC unit, which happened to be me. And so one of the things that we recommend is that if you're going to have repairs done, hire a property manager or hire a third party to come out and fix the issues, because that continues to keep the protection for you. If I'd hired an HVAC company to fix the heating and cooling unit, then that HVAC company would be sued along with the LLC, and my personal assets would be protected. And so this is very important to note that if the LLC is not structured properly, meaning that you aren't doing the work for the LLC, then you won't be protected. So if it's structured properly, you will be protected, and you're not performing the work, you will be protected. If you're performing the work and doing the maintenance, the LLC is going to offer you limited protection because you're the negligent party. Okay. Now, again, the LLC does not avoid probate court, and the LLC does not protect your assets from nursing home and long-term care costs. And again, LLCs don't automatically protect you from the lawsuits. You have to make sure that you were not the person who performed the negligent work that caused the issue. Okay. So again, the common mistakes that we see real estate investors make are, number one, they don't properly title their assets within the LLC. And then number two, they mix their personal and business funds together. And number three is they don't have enough protection for the LLC. And the protection that we recommend as a second layer of protection for the LLC would be some sort of general liability insurance, right? So a couple years ago, I think about 2 years ago now, one of my clients had a piece of real estate and the tenant's son caught the porch on fire. Now, the tenant's son caught the porch on fire, and a couple things happened. Number one, the porch caught on fire, but it did so much damage to the kitchen and the back bedrooms that it almost cost, I think, just shy of $100,000 to do the repairs. In addition, the tenant had insurance, but the tenant's insurance only covered $75,000. But the landlord had another policy which covered the difference. So that was a big plus for the landlord in that situation. In addition, the landlord had a special coverage in his policy that covered lost rents. So um, the the insurance company paid the landlord a year's worth of lost rents for this property because it was covered. Now, I've seen several policies that didn't include lost rent coverage, and so there was that, which was another plus. And so there was enough protection in the policy. In addition, the tenant had coverage where they would pay for the tenant up to a year to find a new place. So the tenant can live in a hotel or rent another place for up to a year while this property is being rebuilt. So there was a lot of coverage in place to protect the landlord, to protect the tenant, and then also in regards to the LLC, because the LLC had to have a policy that would rebuild the property. So the important thing to note is that an LLC is a tool, but it's not a complete asset protection plan. And for a lot of our clients, when we start looking at kind of a complete asset protection plan, what we'll do is we'll set them up an LLC, but we also set them up with a holding company. And the LLC owns the property, the real estate LLC owns the property, and then we'll set up a holding company as an LLC so that the money can be transferred into the holding company as an added layer of protection. Okay. Any questions on that? And I know I'm dropping a lot on you guys today. Okay. Now, the next thing I want to talk about are trust and how trusts work for real estate investors. The first thing I want to say when we're talking about trust is it's important to note that there are many, many different types of trust. And there are, real estate trust, there's land trust, there's living trust, there's revocable trust, there's irrevocable trust, there are gun trusts, special needs trust. There's a lot of different types of trust. But what's important to know is that a trust functions with three main components. The first is the trust agreement, and the trust agreement is kind of how the trust will be managed. Like, what are we going to do within the trust? Okay. Or is all this money supposed to come in and then we spend it every single year? Or are we supposed to take 20% of the money and then reinvest it? So the trust agreement kind of lays out how we're going to handle the money, who gets access to the property. Does all the property have to be sold? Can your children live in the property, and so forth. Now, the next portion of the trust is what I like to call the parties, which are the trustee who follows the terms of the trust. But then we also have the beneficiaries, the people who benefit from the trust. And then we have the grantor or the settlor, the person who creates the trust and puts their assets into the trust. Now, again, the trustee is very important because they have to abide by the terms of the trust for the benefit of the beneficiaries. So if I create a trust and I name my children as the beneficiaries, then my trustee can only use the assets that are in the trust for the benefit of my children. Which brings me to the last portion, which is what assets actually go into the trust, and that's our trust property. And so, again, like we talked about at the beginning of this, assets have to be titled in a certain way. If I have a piece of real estate that's in my name, then the real estate is not inside of my trust. In order for it to get inside of my trust, I have to change the deed to the name of my trust. So I have to transfer it out of my individual name and into the ABC trust. And so now it will be protected. Okay. So the main reason real estate investors and non-real estate investors use trust are because number one, it avoids probate, right? That whole probate process that we were talking about, where $250,000 of assets may cost your family almost $20,000. A trust avoids probate altogether. Okay. Any assets that are in a trust avoid the probate process because they're properly titled and they go directly to the heirs. So it makes a simple transfer of your assets from one generation to the next generation. In addition, a trust maintains privacy. You see, as a part of the probate process, the executor or the administrator has to collect all of your assets and they have to file an inventory with the probate court listing all of the assets. So a trust maintains privacy and it keeps all of that quiet, right? Nothing becomes a matter of public record because it stays out of the probate court. Nobody can say, hey, I want to see what the inventory for this person is. It stays out of the public record. And then the last reason that real estate investors use trust are because it gives us certain tax advantages. And one of those being what we call a stepped up basis in tax. So, for example, if I bought a piece of property that was worth $50,000 when I buy it, and then it appreciates to say $200,000. If I were to sell that property today, I would have to claim income on $200,000 minus $50,000, which is $150,000 of taxable income. However, if I transfer that same property to my trust and then I pass away and my trust sells it, my children get a stepped up in tax basis to the value at the time I passed away. And so they don't have to pay $150,000 in taxes. So if I died and it was worth $180,000 and then they sold it for $200,000, they would only have to pay the difference of $20,000. 200 minus $180,000. And so the trust gives us certain tax advantages by giving us that stepped up tax basis when it comes to appreciating property. Now, as I said earlier, there are many different types of trust, but for real estate investors, we focus on two main types of trust. One being a living trust, which is a revocable living trust where you have control over your trust during life, and then typically the assets are distributed at the time of death to your heirs. Again, this avoids probate and it allows for a smooth transition of the assets to the heirs. The second type of trust that we commonly assist clients in setting up is what I call the Medicaid Asset Protection Trust. Now, this is an irrevocable trust that is used to protect your assets in the event that you have to go into a nursing home. And so, one of the things that I like to talk about is that most middle class Ohioans pay for long term care one of three ways. Either they're private pay, they qualify for long term care insurance, or they qualify for Medicaid. Now, private pay locally, the bill is anywhere from $7,000 to $9,000 on a monthly basis. And so what that means is if you have a nest egg of $100,000 in a year, it's basically wiped out. So what our team does as a legal strategy that's recognized here in Ohio and across, I think, almost all 50 states is the Medicaid Asset Protection Trust. And so what we do is we take some assets out of your name and we transfer them into this trust so that your family members and you can qualify for the long-term care assistance that you need. And so now you're not private pay, but rather the government, which has a state and federally funded program to specifically take care of elderly individuals, they take care of you while we have your assets protected. Now, one of the things that always comes up when we're talking about this asset protection strategy is something that's called a 5 year look back. And people always ask me, well, what is this 5 year look back? And the 5 year look back is a retroactive look back from when you apply for long term care. So if I were to go into a nursing home today, what we would need to do is look back to see what assets I had the previous 5 years, right? So 60 months. And so they're going to want to see, did I have any assets in my name that could have been used to take care of my nursing home bills? And so what our team does is we put that plan in place as soon as possible. My dad would always say, the best time to plant a tree was 25 years ago. The next best time to plant a tree is today. And so, what our team does is we set you up with that asset protection trust today so that your assets can be protected in the event that you have to qualify for long term care. And one of the things in order to qualify for that long term care planning is they want to look at your assets and they identify what we call countable assets. Now, under Ohio law, individuals to qualify for Medicaid, you can only have $2,000 worth of countable assets. So that's $2,000 in a checking, IRA, 401k, whole life insurance policy with a cash value, and real estate. So if you have a real estate portfolio, right, even a small one, most likely you're not going to be able to qualify for the Medicaid unless you do some strategic planning, right? In general, your home is not automatically exempt from the nursing home, but what they do is they will allow you to keep your home, but then they'll make a claim on your home after you pass away. And so, again, the best thing to do is to do some proactive planning so that the assets can be protected. And another thing that I always tell people, it's never too early to do the planning, but it can be too late. So early planning is very, very important. So when you work with our team, what we do is we put together a complete strategy that focuses on your LLCs and your trust so that we can make sure that your property ownership is coordinated with your long-term asset preservation strategy. And so we offer a couple different packages and services for our real estate investors. The first is what we call our first line of defense package. Now, this is truly for a new real estate investor. And what we do is we'll set you up with two LLCs, one to own your property and then one to be a holding company. And the holding company will kind of manage the money where title to the property will be held in the real estate LLC. Now, this is very important because it'll give you a solid foundation that we can then build upon. The next package that we offer is our Legacy Builders Elite Package, which is a combination between a living trust and a real estate LLC. And so, again, this allows you to have two separate layers of protection, which number one is asset protection, and number two is protection against going to the probate court. And so we use the LLC and the trust, the living trust, in conjunction to do two things. Number one, to make sure that your assets are protected against lawsuits and potential liability. And then number two, we want to make sure that if you were to pass away, your assets avoid probate court and we can have a smooth transition for your loved ones. So that's our second package. Now, our third package, which is our Investors Elite Asset Protection Package, it includes the Medicaid Asset Protection Trust and either a living trust and the real estate LLC or two real estate LLCs, depending on your situation and your portfolio size. And what we found is that this combination of the asset protection trust along with the real estate LLCs allows for additional protection so that if you have to go into a nursing home, your assets are protected and you can have the peace of mind to know that none of your assets are going through probate court. And then if a tenant were to sue you, you would be protected as well. And so one of the things that I want to say that we see investors make, like the pitfalls that we see them fall into, is number one, they only rely on the LLC and they don't have a trust in place. Number two, we don't see them having all their properties titled correctly. And so that creates kind of an issue. Just the other day, my team and I, we sat down with an individual whose wife had passed away, but they owned over 50 properties and they owned the 50 properties in their name, right? So they're headed to probate court. Some of their properties were in survivorship. Some of their properties were not in survivorship. So the ones that were not in survivorship headed directly to probate court. The ones that were in survivorship will be able to transfer for those. And so it's very important that you have the properties properly titled so that it could avoid the headache. The last thing that I'll say is that we see people don't have a plan for incapacity. I think it was about a year ago, might be 2 years ago now. I was working with a real estate investor who wanted to buy 10 properties. And the issue that had arose with the real estate investor was as he went to buy the properties, what made the deal attractive for him was that the owner of the properties had passed away. And so that made it attractive for my client as the real estate investor, but it made it extremely complicated because the owner of the property had passed away. In addition, the owner of the property passed away. The assets were not in an LLC. Okay. They were in his individual name. He did not have any estate plan. His mom was incapacitated with dementia, and she was the heir. And so, in this particular instance, the bank filed the foreclosure action to take possession of the properties because no one from the family, his mom nor his stepfather, wanted to open up an estate because when they crunched the numbers, all of the properties were less than the amount that was owed on the mortgage. And so the bank got involved, and it took a year and a half before they could sell the properties and my real estate investor could buy. And so, again, if there had been some proper structuring with the properties and some sort of estate planning and asset protection, that whole scenario could have avoided probate. The family would have had the authority to sell the property, but rather than the family having the authority to sell the property, it was the bank that got the authority to sell the property. So for my client, it ended up working out, but for the family, it didn't. Because here's another thing. There were tenants living in all 10 of the properties, and they didn't know who to pay their rental payments to. And on one particular property, I remember the lady, the tenant, she called my office because the water had been shut off because along with her rent included all of her utilities. And the water had been shut off because nobody paid, the utilities after he died. And so she was wondering legally what could she do? And she didn't want to be responsible to pay the rent and the utilities. So ultimately, she ended up vacating the property. And it didn't have to be that way. So if you have real estate and you're an investor, you need to put a plan in place. We highly recommend our real estate investors elite asset protection strategy and the legacy builder plan to protect your assets. If your family goes to probate court, that is failed planning. Your assets are going to be tied up for 6 to 9 months, maybe even longer. Your family's not going to have the cash flow that they need. And you're going to be facing significant fees in the probate administration process. If you're interested in scheduling a complimentary case evaluation, I'm going to put the link here in the chat, and you can schedule a meeting with my team and we'll be able to go over the ins and outs of real estate asset protection for real estate investors. And as always, remember, where there's a will, there's a way. Where there's no will, then there's probate. But the best plan is a trust plan. And I'm your trust man. I'll see you guys next time. Have a good one.